Law on partnership. Rules to determine whether a partnership exists. Persons who are not partners as to each other are not partners as to third persons except when a person represents himself or consents to another representing him to anyone as a partner in an existing partnership, or with the one or more persons not acting partners. Co-ownership or co-possession does not of itself establish a partnership, whether such co-owners or co-possessors do or do not share any profits made by the use of the property. The sharing of gross returns does not of itself establish a partnership, whether or not the persons sharing them have a joint or common right or interest in any property from which the returns are derived. The receipts by a person of a share of the profits of a business is a prima facie evidence that he is a partner in the business. The receipt of a person of a share of the profits in the business is a prima facie evidence that he is a partner in the business. Exceptions. No such inference shall be withdrawn if such profits were received in payment as a debt by installments or otherwise, as wage of an employee or rent to a landlord, an annuity to a widow or representative of a deceased partner, and as interest on loan, though the amount of payment vary with the profits of the business, as the consideration for the sale of goodwill of a business or other property by installment or otherwise. Kinds of partnership. As to object, universal partner. The kinds of partnership are as to objects, as to liability, as to duration, as to representation to others, and as to representation to others. As to object, universal partnership. A universal partnership may either be a universal partnership of all present property or a universal partnership of profits. Universal partnership of all present property. This is a partnership in which all the partners contribute all the property which actually belong to them to the common fund, with the intention of dividing the same among themselves, as well as the profits which they acquire therewith. Property which shall belong to the common fund. Property belonging to the partners at the time of the constitution of the partnership. Present property. Profits that may be acquired from the present property. Property acquired by each partner after the formation of the partnership, but only if stipulated. This property shall include the property itself, except the stipulation shall not include property acquired by inheritance, legacy, or donation. The profits and fruits therefrom, including those from property acquired by inheritance, legacy, or donation. Example: A and B formed a universal partnership of all present property. At the time of the establishment of the partnership, A owned a fleet of taxis which he had purchased and an agricultural lot which he had inherited. B, on the other hand, owned an apartment which he had earlier acquired by exchange and shares of stock which were donated to him. The partners agreed that property acquired by each partner after the formation of the partnership shall belong to the partnership during the first year of operations. The partnership took place. Fair revenues of 200,000 were realized from the operation of the fleet of taxis. Crops amounting to 100,000 were gathered from the agricultural lot. Rentals of 150,000 were collected from the apartment. Dividends of 50,000 were received from the shares of stock. A coconut plantation was purchased by A from his own funds. Coconuts worth 80,000 were gathered from the coconut plantation. Fish pond was received by A by way of donation from a rich uncle, and fish valued at 70,000 were harvested from the fish pond. Based on the following, belong to the partnership. Fleet of taxes, agricultural lot, apartment, shares of stock, fair revenues, crops gathered from agricultural lot, rentals from the apartment, dividends from the shares of stock, coconut plantation, coconuts harvested and fish harvested. The fish pond belongs to B because the stipulation on future property does not include property acquired by inheritance, legacy, or donation. However, the fruits therefrom, represented by the fish gathered, belong to the partnership. If the property stated in the stipulation was acquired by inheritance, legacy, or donation, it does not or it is not included in the property of the partnership, but the fruits or the fruits therefrom are belonging to the partnership. If it is a universal partnership of all present property, universal partnership of profits, this comprises all that the partners may acquire by their work or industry during the existence of the partnership. Article 1780. Profits property which shall belong to the partnership. Profits obtained by the partners by their work or industry during the existence of the partnership. Accordingly, profits acquired by the partners without the exertion of physical and intellectual efforts, such as those acquired by the chance or the patent titles, are excluded. Okay. Of universal partnership of profits. The use of the property belonging to each partner at the time of the constitution of the partnership. The ownership of the property, whether movable or immovable, belonging to each partner at the time of the constitution of the partnership shall continue to pertain exclusively to each partner, as only the usufruct is passed on to the partnership. Okay, the profits and fruits of the properties aforementioned be fruits and profits is if stipulated of property acquired by each partner after the constitution of the partnership. A and B formed a universal partnership of profits. At the time of the establishment of the partnership, A owned a fleet of taxes which he had purchased, an agricultural lot which he had inherited. B, on the other hand, had an apartment which he had earlier acquired by exchange and shares of stock which were donated to him. The parties stipulated that fruits of future property shall belong to the partnership. During the first year operations of the partnership, the following transactions took place during the year or within the operation of the partnership. Fair revenues of 200,000 were realized from the operation of the fleet of taxes. Crops amounting to 100,000 were gathered from the agricultural lot. Rentals of 150,000 were collected from the apartment. Dividends of 500,000 were received from the shares of stock. Salary of 500,000 was received by A as professor of a certain college. 1 million was won by B in the lotto draw. A coconut plantation was purchased by A from his own funds, and coconuts worth 80,000 were gathered from the coconut plantation. Fish pond was received by B by way of donation from his uncle. Future fish valued at 70,000 were harvested from the fish pond. Based on the foregoing, the following belong to the partnership: the fair revenues, the crops gathered from agricultural lot, rentals from the apartment, dividends from the shares of stock, and salary of A as professor in a certain college. Even the salary of A as the professor of a certain college is included or belongs to the partnership. Coconuts gathered from the coconut plantation. Fish harvested from the fish pond. The fleet of taxes and agricultural lot shall continue to pertain to A. Fleet of taxes. of that. While the apartment and shares of stock shall continue to pertain to B, since only the use and fruits of the said properties were contributed to the partnership at the time of its establishment. The coconut plantation belongs to A because it is not a fruit. The lotto winnings and fish pond belong to B since they were acquired by chance and lucrative title respectively. However, the coconuts gathered and the fish harvested belong to the partnership because of the stipulation that fruits of future property shall belong to the partnership. Rule in case universal partnership is without any specification. Articles of universal partnership entered into without specification of its nature only constitute a universal partnership of profits. Okay. If there is no specification in accordance to its nature entered into the articles of the universal partnership, then it will only constitute to the universal partnership of profits. This is so because a universal partnership of profits transmits less rights and interests. If the doubt refers to the incidence of a gratuitous contract, the least transmission of rights shall prevail.